All right. Good morning, everyone. My name is Jeffrey Salant. I am the I am the HOA Information Officer for the Division of Real Estate, which is a division of the Colorado Department of Regulatory Agencies, also known as DORA. This morning, we are going to talk about all of the information you should know before purchasing a home in an HOA. And if you live in an HOA already, some of this information may also be helpful to you. There are 3 handouts attached to this webinar: a PDF copy of this presentation, a copy of the Colorado Common Interest Ownership Act, also known by its initials CCIOA or CCIOA, and a copy of the Colorado Nonprofit Act. You may download them directly by clicking on the blue links located under the Handouts tab on the GoToWebinar control panel. In case you are unfamiliar, this is what the GoToWebinar control panel looks like. The highlighted section right here shows you where you may access the links to today's handouts. If you are having any trouble accessing the handouts, please feel free to contact me after the webinar for copies. Please note that the information provided during this presentation is for educational purposes only and is not meant to provide or to be construed as legal advice. Any legal questions should be directed to your attorney. Before we get into the presentation topics, I'd like to take a moment to talk with you about my office, the HOA Information and Resource Center. The HOA Center is a statutorily created office, and my position, the HOA Information Officer, is appointed by the Director of the Division of Real Estate. Per statute, the HOA Center provides information to homeowners regarding their basic rights and responsibilities under CCIOA. It gathers, analyzes, and reports information through complaints and HOA registrations, and it also writes an annual report to the legislature. It creates resource materials, provides education, and presents HOA forums just like this one. The HOA Center also maintains a website with information for the public and also registers HOAs. As for what the HOA office does not do, the HOA office is not a regulatory program. It does not mediate or arbitrate. It cannot provide legal advice. It does not act as an advocate. It cannot assess fines or penalties, and it may not enforce an HOA's failure to register. So many of Colorado's new home buyers will purchase their home in a development or a condominium that is in a homeowners association. It is important that you know the implications of buying in a particular HOA prior to purchasing your home there. During the transaction process, disclosure of the existence of an HOA is required in Section 7 of the Colorado Contract to Buy and Sell Real Estate. Common interest communities offer many benefits, but homeowners should understand that there are covenants, rules, and regulations which can have a significant effect on how you live in your home and the decisions you make regarding your property. I mentioned the term common interest communities. Common interest communities are a more formal term for HOAs. An HOA describes a certain type of real estate and form of home ownership and a lifestyle that is becoming more common. HOAs, or common interest communities, are the fastest growing form of housing in the United States, and they are also referred to as condominium owners associations or property owners associations. In an HOA, the owner of a unit or a lot owns their lot or unit in addition to sharing in the ownership of the common areas with other homes or property owners. Typically, the purpose of an HOA is to control the appearance of the property, maintain the common area, and to provide residents with shared amenities. Homeowners who purchase in an HOA are responsible for paying their share of the dues and obeying the covenants, rules, and regulations of the HOA. Being in an HOA means you receive the benefits of common ownership, which include providing you with shared neighborhood values, an opportunity to enforce uniform regulations, the ability to increase property values, and to provide recreational amenities. Additionally, when you purchase a home in an HOA, you agree to restrictions on the use of your property through covenants and rules. Decisions made by persons who you may not know can affect the use and enjoyment of your property, your lifestyle, freedom, and finances. There may be decisions made by a few persons on an executive board or committee that do not reflect the view of the majority of homeowners in the community. If you do not agree with decisions made by the board, your first remedy is to use the democratic process. Seek election of other members of the HOA that are more sympathetic to your concerns, which may be a difficult process in an HOA where members are not very active. You may also wish to attend board meetings and appropriately voice your concerns on any given issue. With respect to items that the board has complete authority over, such as hiring a community association manager or the manner in which maintenance is performed, this may be the extent to which you are able to influence the outcome, simply speaking your mind at the appropriate time during an appropriate meeting. However, in circumstances such as covenant violations or architectural review committee findings, you may engage your board in alternative dispute resolution, such as mediation or arbitration. However, this is a voluntary process, and if your board refuses to participate in the process or the process is unsuccessful, then your last resort will be to contact an attorney and file suit in court. We will be talking more about alternative dispute resolution later in the presentation. In addition to any mortgage, you will also be responsible for paying HOA dues, which may change, and special assessments may be levied, which may require a large unanticipated capital contribution from the members of the HOA. As a homeowner, you will pay your shares of assessments for as long as you own your property. Generally, there are two types of assessments in HOAs: regular, also known as dues, and special. Regular assessments are typically paid on a monthly, quarterly, or annual basis, while special assessments are usually less frequent and made on an as-needed basis. Regular assessments generally go towards the overall operational maintenance costs, while special assessments are generally for a specific purpose, such as a repair, replacement, or perhaps new construction. When budgeting for a home purchase, as a potential buyer in an HOA, it is essential to know what the dues are and to understand whether additional special assessments are projected. According to Colorado law, during the negotiation of the purchase of residential real estate, the seller is required to disclose whether the property is in an HOA. Prior to making a decision, new homeowners should obtain and review all of the documents required to be provided by Section 7 of the Colorado Contract to Buy and Sell in order to determine the financial health of the HOA. The seller should provide you with the HOA documents, including a copy of the covenants, bylaws, minutes of the most recent annual owners meeting, minutes of any board meetings, and the most recent financial statements, if available, during the 6-month period immediately preceding the date of the contract. While brokers should assist in facilitating the provision of these documents for their clients, they should not try to explain them. Any questions about governing documents or financial records should be addressed with a qualified community association attorney and/or a qualified certified public accountant. While membership in some HOAs is voluntary, the vast majority of HOAs in Colorado are mandatory. This means that membership is automatic upon purchasing your home, townhouse, or condominium when it is located in a common interest community. The relationship between an association and its members is a contractual relationship. The contract terms are the governing documents collectively as supplemented by CCIOA, the Colorado Common Interest Ownership Act. When you purchase property located in an HOA, the recording of your deed is similar to your signature on a contract, agreeing to abide by all of the governing documents, including the covenants, conditions, and restrictions. The Colorado Common Interest Ownership Act, again frequently referred to by its initials, CCIOA or CCIOA, governs HOAs in Colorado. Most of the important provisions in CCIOA apply to all common interest communities, regardless of when those communities were created. However, some provisions apply only to communities created after July 1st, 1992, the date in which CCIOA became effective. Additionally, it is a requirement that HOAs incorporate as either a nonprofit corporation, for-profit corporation, or an LLC, all of which are governed by Colorado corporate laws. Foremost, the laws of contract and property, through the governing documents of the HOA, govern the relationship between the HOA and the homeowner. Again, the governing documents include the declaration, also referred to as the Declaration of Covenants, Conditions, and Restrictions, or CC&Rs, articles of incorporation, bylaws, and the rules and regulations of the association. Even if the governing documents expand on the rights of homeowners, they cannot contradict or diminish the rights as provided in CCIOA. CCIOA defines the rights of unit owners as well as those bestowed upon the association. It also defines the responsibility of an association as directed by its executive board. CCIOA provides for the enforcement of those rights and responsibilities through civil litigation. Unfortunately, the state has no authority to intervene in any association member's conflict with their association, nor does it have any jurisdiction to enforce the rights and responsibilities defined in CCIOA or an association's governing documents. Succinctly speaking, there is no regulatory oversight of HOAs or community association managers in the state of Colorado. Any dispute between homeowners or homeowners and an HOA is considered a civil matter. So what are covenants? Covenants or restrictive covenants are a legal obligation in a deed to do or not do something. When a homeowner takes title of the property in an HOA, they are subject to the covenants that are enforced by the HOA. Typical covenants may include a prohibition against a certain color of house paint, restriction on pets in a condominium, and restrictions on commercial vehicles on the property. However, HOAs may also restrict what you can do with your own backyard, including the regulation of additions to your home and property, such as storage sheds, hot tubs, and patios or decks. In addition to covenants, most HOAs have rules and regulations that further restrict the use of the common area. Covenants contained in the declaration run with the land, meaning that when you buy the property, you have no say in whether to abide by them, and you cannot modify them during the negotiation of the purchase of your home. Although the HOA can amend covenants, it takes at least a majority of the homeowner votes to take such action. One of the most powerful tools available to HOAs in Colorado is the statutory lien. The statutory lien exists on any unit for any assessment levied against that unit or fines imposed against its unit owners. Increasingly, unless an association's declaration provides otherwise, CCIOA describes the term fines imposed to include fees, charges, late charges, attorney's fees, fines, and interest. The association has a super lien, meaning it has priority over all other liens. Generally, liens have to be recorded to be perfected. However, in Colorado, the recording of an association's declaration constitutes record notice and perfection of the lien. The association need not take any further recordation of any claim of lien for assessments for the lien to be valid. Interestingly, an association has 6 years from the time the full amount of assessments become due to institute enforcement actions. A lien for unpaid assessments is extinguished unless proceedings to enforce the lien are instituted within such time frame. What are bylaws? Bylaws are the corporate legal instruments adopted by the HOA for the regulation and management of the HOA. They are required by Colorado corporate laws and generally contain information regarding the specifics of different areas of community association governance. The bylaws of an association must provide for the number of board members and their titles. It must describe the process for election and removal of board members. It must describe the qualifications, powers, duties, and terms of board members, the powers the board may delegate to others, the method by which bylaws may be amended, and should also provide for any other matters the association deems necessary and appropriate. What is community association management? Well, community association management involves all aspects of operating a common interest community, or HOA. In a self-managed community, the association will utilize volunteers, specifically the board of directors, to do all of the work. Everything from the management of the association's daily routine tasks to the enforcement of rules is done by the volunteers from within the association. The roles and responsibilities of the board can generally be divided into delegable duties and non-delegable duties. Delegable duties may be delegated to volunteers, while the board must execute their non-delegable duties themselves. What is professional community association management? Well, generally speaking, it involves performing services as the agent of the board of an association. As agent, the community association manager, or CAM for short, performs services in connection with some or all of the delegable duties of the board. These duties might include the collection of dues, enforcement of covenants, rules and regulations, the sending of notices, record retention and production, bookkeeping, drafting a proposed budget, filing insurance claims, and assisting the board in coordinating meetings. These are just some of a board's delegable duties. Some examples of a board's non-delegable duties might include voting on community issues, voting on appeals of community violations, adopting a budget, and waiving fees, fines, or fines levied by the association. CAM licensing and regulation previously existed in the form of the CAM program housed in the Division of Real Estate from January 1st, 2015 to July 1st, 2019. In May of 2019, the General Assembly passed House Bill 19-1212, which concerned the recreation of the CAM licensing program. The bill would have continued the CAM licensing program administered by the division for 1 year. However, on May 31st, 2019, Governor Polis vetoed HB 19-1212, and the CAM program expired on June 30th, 2019. In addition to his veto, the governor also issued Executive Order D 2019-006, which directed a stakeholder process to examine community and homeowner associations. Currently, there is no regulatory oversight of HOAs or community association managers. So why are we talking about this? Well, the importance of understanding CAMs and what they do is important because although neither the HOA Center nor the Division of Real Estate have any investigative or enforcement capabilities to address HOA complaints, we do accept complaints and record the issues and matters of concern into a statistical database, which is later compiled into an annual report for consideration by the state legislature. During 2020, 21% of all complaints received by the HOA Center were filed against a community association manager directly, and an additional 16% were filed against both the manager and the board. It is important as a homeowner to understand the distinction between the board for your HOA and the management company. Whereas the management company is responsible for the day-to-day maintenance and upkeep of the HOA, the board is ultimately responsible for all decisions of the HOA. Before purchasing in an HOA, you may want to learn the name of your management company and research its reputation, since they will also become a part of your life in an HOA. One of the most frequently asked about topics regarding HOAs here in Colorado is meetings. Generally, there are 3 types of meetings in an HOA: meetings of the unit owners, special meetings, and board meetings. All regular and special meetings of the association's executive board or any related committees are open to attendance by all members of the association or their designated representatives. Agendas for meetings of the executive board are to be made reasonably available for examination by all members of the association. Unfortunately, Kiowa does not define reasonably available. Meetings of the unit owners of the association are to be held at least 1 time per year. These meetings are usually held for election purposes, budget approval, amendments to governing documents, and other important matters of interest to the association and its members. Notice of the owners' meeting must be given not less than 10 days and not more than 50 days in advance of any such meeting. The secretary of the association or another official specified in the bylaws must deliver notice of the meeting to each unit owner. The notice must be physically posted in a conspicuous place and is in addition to any electronic posting or email notices that may be sent out. The notice must state the time and place of the meeting and the items on the agenda, including the general nature of any proposed amendment to the declaration or bylaws, any budget changes, and any proposal to remove a member or officer of the executive board. Special meetings of the unit owners can be called by the president, a majority of the executive board, or by unit owners having 20% of the votes in the association, or any lower percentage as stated in the association's bylaws. All regular and special meetings of the association's executive board or any related committees are open to attendance by all members of the association or their designated representatives. Agendas for meetings of the executive board are to be made reasonably available for examination by all members of the association. Notice requirements for board meetings are usually described in the association's bylaws. Interestingly, CCIOA is silent on the notice requirements for executive board meetings. While there are generally only 3 types of formal meetings, another form of conference that is commonly found in HOAs are working sessions or work groups. Although not specifically defined in CCIOA, work or study sessions of boards or their committees are also not prohibited by it. However, they still must be in accordance with the community's governing documents and policies. But since they are not considered meetings due to the lack of actions or votes on community issues, the unit owners do not have a right to participate and do not need to be noticed of the conference. The final topic that we will discuss is alternative dispute resolution, or also known as ADR. Since there is no regulatory oversight of HOAs in Colorado, many disputes between homeowners and an association end up in court. The Colorado General Assembly has stated that the cost, complexity, and delay inherent in court proceedings make litigation a particularly inefficient means of resolving neighborhood disputes. As such, HOAs are encouraged to adopt protocols that make use of mediation or arbitration as alternatives to the filing of a civil complaint between a unit owner and an association in those situations that do not involve an imminent threat to the peace, health, or safety of the community. And while any controversy between an association and a unit owner may be submitted to mediation by agreement of the parties prior to the commencement of any legal proceeding, it is still a voluntary process. If both parties do not agree to the ADR, it may not be mandated unless ordered by a court. If ADR is successful, the parties may present the argument to the court for approval as a stipulation. But again, any party to voluntary ADR may terminate the process at any time without prejudice. The declaration, bylaws, or rules of the association may also specify situations in which disputes shall be resolved by binding